they're very important issues legally because the law has to categorize things. And when it categorizes things in a way that omits people, it's very hard to make change because people point to the law and then say, oh, but it's illegal. I mean, as they did for so many years with the sodomy laws, to say, well, you know, we can't accept marriage for same-sex couples. Sodomy, they commit sodomy and it's illegal in our state. There had never been a federal definition of marriage. It always had been state law. And DOMA came about, if you remember way back when in Hawaii, when they thought, in the Bear versus Lewin case, they thought that Hawaii was going to be the first state that had same-sex marriage. And the fear that that caused led to the Congress passing the Defense of Marriage Act and Clinton signing it. And as a result of that, though one is married legally now in Massachusetts and some other states, there are a lot of ways in which DOMA now is forcing a state, and this was Martha Coakley's argument, that the state of Massachusetts is being forced to discriminate against its own citizens, and that the federal government is requiring it to discriminate against its own citizens by its definition of marriage through DOMA, which is a congressional act, not a constitutional provision. And that in so doing, it's really a violation of equal protection of the law. The constitutionality of the Defense of Marriage Act is now being challenged, and that is really somewhat the last barrier to equal protection under the law for gay couples who would wish to be married, because it's DOMA that has stood in the way of those of us who are married legally under state law having that recognized by the federal government. And it's being challenged both from the Massachusetts ruling recently, in which the judge not only denied the request of the government to dismiss the case, but found for the plaintiffs, which were Martha Coakley on behalf of Massachusetts and Glad on behalf of some plaintiffs, he found in their favor in summary judgment, which means it's over at that level. Now the question is, will it be appealed by the Obama administration? We know that there's been some sign that the Obama administration would like not to appeal it, but it's almost impossible for them not to appeal when a court finds a federal law unconstitutional. And so undoubtedly it will be appealed. So it will go to the First Circuit and then to the Supreme Court. At the same time, we have the California Proposition 8, which is being challenged on constitutional grounds, and it could well end up that those are going to be both presented to the Supreme Court ultimately, and it could be clearly not this term, but probably the next term. The transgender movement has had a huge impact on the law. And I think that for those reasons, both of them are very interesting to me, because I think that both of them are really going to be at the heart of what emerges, I hope, as a country where sexuality and gender, as one, there was one article I read where these parents, not your usual parents, said, you know, somebody asked them, well, what is your child? They just had a baby, and he said, well, we'll wait and see what he or she tells us.